Good morning and welcome to an oral argument session of the 5th District Court of Appeals. Today we have the case of Crystal Palace Resort PB LLC versus the Agency for Healthcare Administration. My name is Mary Nardella and I will be presiding today. And I am joined with the Honorable Judge Cohen, Jay Cohen from our court, as well as visiting from the 9th Judicial Circuit. We're lucky to have the Honorable Judge Louis Calderon. Today, each side will have 20 minutes. The appellant, Mr. Terrell, will reserve 5 minutes for your rebuttal unless you tell us otherwise. We're being recorded today. I'm sure you guys are aware of that. And with that, you may proceed, Mr. Terrell.
Okay, good morning, and may it please the court. And thank you. I would like to reserve the 5 minutes, Judge Nardella. This case, I represent Crystal Palace Resort, and this case, as you can tell from the record, has been pending for quite a while. We're going on 4 years now. And although a number of issues have been raised during the appeal, there are two that I emphasized in the reply brief, and that is, the first one was ACA's failure to comply with 408-806-3C in issuing the notice of intent to deny timely, and the second was ACA's failure to comply with 408-811 subsection 4, which is the 30 days to correct a deficiency that's cited during a survey. Turning to the first issue, this statutory provision is not permissive, it's mandatory. It says that the agency shall approve or deny within 60 days of the completion of the licensure process. And as you can tell from the record, we already went through at least one final hearing and a second one. The first one resulted in a final order on August 15, 2018, in which the judge determined that there were no grounds for revocation, that the notice of intent to deny should be vacated, not because of anything that Crystal Palace did, but because ACA failed to conduct a survey tied to the renewal license. So basically, that was adopted in the final order. We then have the renewal license survey taking place on September 12, 2018. ACA cited the facility for a number of alleged violations. And then what usually happens with these surveys is they have 30 days to correct it. My client filed a plan of correction on October 15, 2018. However, ACA did not return to the facility until December 5th, 2018. This is the pertinent date because this is the one that ACA conceded below is the end of the licensure application process. And this was during the filing of motions, a motion for summary judgment and their response. And they conceded this was the date. However, and this sort of ties into 120.601, which is the default license provision. And that states that if you start the deadline at certain periods of time. First is upon receipt of all the information required, a correction or any error or omission, or when the time for such notification has expired. So basically, October 15, 2018 is when my client responded. ACA didn't show up till December 5th, 2018. That's when they showed up.
But doesn't this presuppose that a complete application was submitted?
Yes, there was no problem with the paper application submitted in this case. That
Well,
was
my question is, what statute defines what constitutes a complete application?
I'm not sure that there is one. What ACA usually does is they review the paper, and then they schedule a survey. And going back, I think the paper was first filed on this case in February of 2017. And as you can tell from the judge's finding, the ALJ's finding in the first case, there was no problem at all with that application. There was no survey conducted tied to that application.
I mean, depending on the statute, the availability to Crystal of the default license would be dependent under either statute, the satisfactory completion of an examination, correct?
I don't find that in any statute that says exactly that. 120 does say subject to satisfactory completion of an examination, but there is no statutory definition of what that means. Now, there is a rule that ACA relied upon, but I can find no statutory justification that supports that rule.
Doesn't the Mila case stand for the proposition that that you need both, that an examination includes a pre-licensure inspection? And if so, do you disagree with that?
Well, you need the inspection. I'm not disagreeing with that. What I'm disagreeing with is I think the rule goes too far, because the rule says it defines what a satisfactory inspection, which is one where basically there's no deficiencies. There's no violations, or they've
To
been
make a
corrected.
constitutional challenge to the validity of the rule below?
We did not do a rule challenge, but there is some language in, I believe, 120 that if this comes up during a hearing, the ALJ should not rely upon a rule that is questionable. But the main thing here, I think, is that, and what's different from MILA is we have a clear statutory directive to ACA, and that was not in MILA. This one is 408.8063C, and this is what I think really distinguishes this case from MILA. MILA didn't have any directive as far as what to do after a recommended order is issued. But this, we have a clear statute 408.806 that's not permissive. It says ACA shall issue the denial or the granting of the license. And this is another thing that's a little different than MILA. In MILA, what they were looking for is a granting of the license. We weren't looking for that. We were looking for a decision. And that's what 408.806 says ACA should do.
Well, this is my question. So this goes back to whether or not a complete application was submitted. Because if you go to 408.806, aren't you then required to look at Florida Admin Code 59A 35.060, in which the third condition is that a satisfactory inspection be completed? So that would constitute a complete application, that all the required information is submitted, all required background screenings or results are submitted, and that a satisfactory inspection is completed for the application to be complete under 408.806.
I think the rule overreaches the statute. The 408.806 doesn't define satisfactory completion to be a deficient-free survey.
In that absence, but in the absence of that definition, don't we look to the Florida Administrative Code?
You could look at it as long as the rule is not directing what the statute should do. And I think that's what's happening in this case. It's sort of like the tail wagging the dog. The rule is an overreach, because if you look at ACA's argument in this and take it to its logical conclusion, you could never have a default license. Because basically they would say, until you get a deficient-free survey, you haven't completed our application process. Well, guess what? That means that instead of 4 years, we could be 6 years into this. And these are biennial licenses. As you can see from the first case, they didn't even complete the survey, and they issued a notice of intent to deny. So, that's what I think makes this an even more compelling case, is look at 408.806.3C. It makes it clear, accept or deny. It's not saying, like MILA was saying, well, you get a license because they didn't act. What this statute is saying, ACA, if you're going to make a decision, which the judge in the first case told them they needed to do, you need to issue that timely, within 60 days. They didn't do it. They issued it on February 12th, 2019, 69 days after they conceded that the licensure renewal process was over. And that's beyond the time limit. So I think there are some, at least in this case, some serious problems with that rule as far as overreach. When I looked at the rule as far as a basis for it, they cite the 408.806. They don't even cite the 120 as authority. And 408.806 does not contain any definition that says completion of an application is a deficient-free survey, because you wouldn't have that. It just doesn't really exist. As you can tell from the first case, you can always find something to cite, and then it's up to the judge or ACA to determine, is this sufficient to deny a license or to grant it. And as you can see,
well, under your reasoning, there wouldn't be an assisted living facility in the state that had a license.
that could get a license.
Yeah, under your rationale, you would there wouldn't be an assisted living facility in the state that was licensed
Well, they would. You just act
because they
within,
are in violations.
they just act within 60 days of the final survey, and then accept it or deny it. And they do it all the time. I mean, that's not the problem. The problem is making a decision, and they just didn't make a decision within the statutory time limit.
Mr. Terrell, can you address what the underlying court found when it came to the remedy that was appropriate for the allegation that ACA did not timely meet its obligation to make a decision? You say it's a license, they say it's not. Can you talk about that?
I missed that last part. I said it was a,
Well, you say you get a renewed license because of their failure.
yes. And I go back to 120.60 in the cases that I cited, Krakow and Premier, where they say, and Krakow probably explains it a little bit more, because in that case, there was some discussion by the court, and that was the chiropractic case, where the board said, no, we want them to take an exam, we want them to do clinical, we want them to take 3 steps of this exam before they get a default license. And the court said, no, once you miss the time limit under 120, and I'm not great at paraphrasing, so I'll just go to the decision. It says the board's failure to timely act on these applications precludes it from exercising its discretion to determine the applicant's qualification for licensure by endorsement in this case.
But even under 120.60, doesn't it still require the satisfactory completion of the examination or of the inspection?
It does, but I don't think there's any language in 120. I can't find any language in 120, 408, or 429 that defines it the way it does in this rule. I think the rule is an overreach. And when you have a clear statute that says you shall approve or deny the license within 60 days of the end of the licensure process, I think ACA should comply with that. And they conceded December 5th, 2018 was the follow-up survey. They came in, they reviewed. Actually, we had some issues about that I raised, where the surveyors basically didn't even look at the corrections. Exhibit 14, which is rather voluminous, contains all the corrections, and 2 surveyors testified they didn't even look at it. So then what's a facility do at that point? Is if ACA is refusing to even look at the corrections to the licensure survey, they're kind of stuck, which is what we have, which is why I raised a number of exceptions and referred this court to the record that my client had produced the material, and it was there. So that's where we are on that. And when we look at satisfactory examination, I think there are other different ways to look at that. When they conduct these surveys, they're sometimes interrupted. They can't get it done. Either the administrator is not there. That could be another definition, another thing when they talk about satisfactory examination. Was ACA able to go in, do what they needed to do, inspect things, write up their statement of deficiency, and send it? And they were able to do that, both in the September 12th, 2018 and the follow-up December 5th, 2018 survey. And it's that end survey where they say, where they've conceded, this is the end of the licensure process. That started.
Just wanted to go back to something you said earlier with regards to 408.806. You said that the agency had 60 days to approve or deny the license. What provision is that? Because I'm looking at 408.8063C, and it says that within 60 days, the agency shall approve or deny the application, not the license. So again, I just want to make sure, are you talking about the definition of the application? Because it's not defined in 408.806. Are you saying that carte blanche, the minute any application, whether complete or not, is submitted, that it must be approved within 60 days?
I think the way the case law and looking at Mila interprets that is the application includes the paper application that gets submitted and then the follow-up survey. And what ACA does is they do an initial licensure survey and then they return within 30 to 90 days. The field office manager testified to conduct the follow-up survey. That's the application. And then
If
once
it's not
that
completed,
occurs,
but if it's not satisfactory, the process continues or it's denied.
or it's denied, right? And that's the issue. Is this is not like Mila where we're looking for an acceptance. What we were looking for was a decision, and that's the crux of this case. Is Crystal Palace isn't going in and saying within 60 days we wanted a license. That's not what we're saying. What we're saying is the statute says within 60 days they shall approve or deny, and they did deny it, but they didn't do it within 60 days. And that, I think, is a crucial distinction.
Well, you are asking for a license, it's, you don't care about the decision, you care about the license.
Well, in this case, under this scenario, yes, because it's 120.60 comes into play. And 120.60 has a 90-day time limit that says if you don't act under the cases that I cited, you get the license. And then the agency has basically defaulted on its ability to question what's going on as far as qualifications. But 408-806 specifically sets a 60-day time limit. And 120 says you defer to the smaller time limit. And that's what's happened here. And the thing that I would like to remind the court is we already went through one hearing where the judge determined that there were no grounds for a notice of intent to deny. They said it should be vacated because ACA didn't comply with its statutory obligations. My client would have had a renewal license if they had done what they were supposed to do. They didn't do it. So here we are doing a second round, and I know I'm running out of time on this, but basically when you look at the survey results and the material that my client produced, we've corrected every of these deficiencies. So anyone that's of substance. The only thing that's left are minor ones, like we have with the first case, where the judge said the NOI should be vacated, not because Crystal Palace had any issue, but because ACA did not conduct the survey that are supposed to do under 408, 807, 806, subsection 7.
I don't know. I mean, the record that I've reviewed, shows that they did these surveys over a period of number of months, and the facility kept having the same errors over and over and over again.
In the records that we produced for the response, it shows that they're corrections. And the thing with the 1823s, and I just want to touch on this. This is the one where ACA cited numerous times. The 1823 is something that is completed by the physician, and the facility can't correct that. Only the physician can correct it. And what ACA did is they went and pulled a bunch of files, including closed files. And closed files are those where the resident has left and is no longer there. And they cited the facility for these 1823s over and over again. And Judge Cohen, that might be what you're referencing. But the problem with the 1823s is the facility doesn't control that. All they can do is ask the doctor to fix it. And that's what my client did. Even on the closed files where the residents weren't even there anymore, they had left 6 months, a year earlier, they went and contacted the doctor, had the 1823s corrected. So that's kind of what we were looking at under this scenario, is that they kept coming back. And then the error on that part is the judge and ACA relied on the rule, which requires 30 days after admission. There were no findings on when the residents were admitted. And
Mr.
again,
Terrell, have you ever seen a nursing home or assisted living facility that didn't get cited for some violations?
I haven't. I think if they want to find a violation, they can find something. I mean, they pulled closed files on this facility. That means the resident isn't even there. They've been gone for a year and a half, And
Why
look
don't you,
through
why
all
don't
the
you
documents.
save, why don't you save a little bit of your time for rebuttal?
Okay, thanks.
Ms. George, whenever you're ready.
It's going to be easier if you unmute.
Sorry, I thought I had.
Okay.
My name is Tracy George, and I represent the Agency for Healthcare Administration, or AHCA, the appellee in this case. The crux of this matter is Crystal Palace is a poorly managed facility, and it should not be relicensed. For this renewal application, it failed 4 attempts at a satisfactory licensure inspection. Over an 18-month period, it committed 25 violations of the ALF law, including 3 Class 3 violations that directly threaten the health, safety, and welfare of
All
its
right, well, why didn't your agency then deny it within 60 days?
Your Honor, the application was never complete. We were waiting for there to be a complete
Yeah.
application.
The difficulty I have with that argument is that, having done some of, having presided over some of these cases as a trial judge, the nursing home Bill of Rights is almost impossible to comply with, precisely. And you can always find, violations. And under that theory, it gives you really carte blanche to automatically extend that 60-day period of time.
Well, Your Honor, this was not a case where there was 1 violation, 2 violations. There were multiple violations every time, and these were not all minor violations. So while theoretically I can see your point, it doesn't apply in this case. This was a facility, the first time we went out.
But the point that was more in the interpretation of what a completed application is.
Right. And this facility, every time we went out there were more new violations, and the ones that were before were not corrected. So, I mean, it says in the rule that you have to have a satisfactory licensure inspection, which means either the violations didn't exist or they weren't corrected within the time period required.
But Ms. George, what do you say to Mr. Terrell's point that the rule is adding something that's not there in the statute? The statute clearly talks about an examination, and it doesn't talk about an inspection. It doesn't add that when it talks about an examination. It doesn't talk about an inspection in that same in the same context, in the same sentence. And then we go to the rule, and the rule is far more specific. And it does appear that it could be adding an element that is not required in the statute. What do you say to that?
Well, first of all, Your Honor, which statute in particular are you speaking of?
120.60.
Okay, that's not the licensing statute. That's the default licensure statute. So the statutes that we need to look at to determine if we have the authority are in chapters 408 part 2 and 429 part 1.
Okay.
Chapter 120 applies to every single agency, not just us. And so we need to look in 408 to see if we have the authority to determine if there's a complete licensure application, and we do. One of the statutes in 408 says that the agency has the authority to promulgate rules to governing the licensure of all the facility types listed there, and there's quite a few. ALFs are just one of them. And so, this is something that we have. And keep in mind, this rule doesn't just apply to ALFs, it applies to every facility type that we license. So this is not something where we're just picking out ALFs. This is something it's a general licensure procedure for all entities that are licensed by the agency. So that it's everything from nursing homes to little 5-bed adult family care homes. So,
was there a challenge made to the rule below?
No, Your Honor. And contrary to Mr. Terrell's representation, the agency never conceded the 60 days. There was the page number that he's talking about, and I tried to find it and I couldn't. In the paragraph above, the agency may have been read to have conceded something, but then when you look at the paragraph directly below, we pointed out that there was no complete survey, and so it was never complete for that reason. So, I don't think we ever conceded anything. This application was never complete. The rule was not challenged. And, again, if this might be something to quibble about in another case, but keep in mind that this was a case where the ALJ didn't even recommend that we grant the license. And that's another one of the things, in addition to having a complete application, that's necessary to have a default license under 120.601. So, I mean, it expressly says in there, if the ALJ has recommended that you don't grant the license, you shouldn't apply this. So we've got more than one ground here under that.
Do you think there's any reason for this court to address the burden of proof issue?
Your Honor, I don't think it's necessary. We do have a little bit of a problem with ALJs not following the Florida Supreme Court cases, but it's really a matter of academics here. The ALJ found that the agency met for all the actual violations that were proven, met the clear and convincing evidence standard, and that we didn't meet the preponderance of evidence for any of the ones that weren't proven. So it's not necessary to address it. There is no property right to an ALF license. It's a privilege, not a right. It expressly says that in 429.01 subsection 3 of the Florida statutes. The reason is that ALFs provide care to a vulnerable population. These are disabled adults. These are frail elderly people. This is a type of license that's an occupation that is potentially injurious to the public. It's not a right here. And so there's no property right in this license. Yes, it is a relicensure case. The Davis case was a relicensure case out of the Florida Supreme Court, so that the Osborne-Stern case does not stand for the proposition that it only applies for licensure. We like the Mila case. We think this case is even stronger because, again, the ALJ denied the recommended order. In the recommended order, he said that you should deny renewal. There's a lot of things here that Crystal Palace would have to show in order to get this license. I mean, we have 4 independent grounds for denial here. We've got 3 class 2s. We've got 5 or more class 3s that were uncorrected. We've got a pattern of deficient performance. We've got the failure to pass the licensure inspection survey. So that's 4 independent grounds for denying this application. Again, 18-month period, 25 violations. The ALJ himself found that one of the telling things was that most of these violations were repeated or committed when they knew that we were coming back out there to survey to see if anything had been corrected. And that it was a reliable sample of Crystal's action.
I think there was a strategic decision here by Mr. Terrell to focus on the 60-day aspect of the case as opposed to whether there was clear and convincing evidence of the violations.
Yes, Your Honor, and that's because that's his best point. I don't think it's a good point, but it's his best point. And one more thing to keep in mind here. This was the first time this facility was licensed. It was licensed in 2015 for the first time. We tried to deny the renewal application and to revoke the existing license before they ever got there to the next renewal. And then we've been litigating this renewal license ever since. This facility is one of the 11th biggest. It was the 11th biggest ALF in the state. It's licensed for 252 beds. Their occupancy is usually around 50. They have a congregate care license that they never used because they couldn't get it together. The owners are the administrator much of the time, but he allows these deficiencies. So this is exactly where the agency is doing its job. We're trying to close down a facility that should not be relicensed. Does anyone have any other questions for me today?
Just one issue that came up with regards to the rule. It uses a terminology when defining a complete application as requiring a satisfactory inspection. If we were to find, which is what Mr. Terrell wants to see, this was a complete application because only a paper application was required. under 120.60, it would still require the completion of a satisfactory completion of an examination. Is there any relevance or any value added to the distinction between an inspection and an examination?
There's a number of reasons we can commit it. We can go out there for a survey. And we generally just call them all surveys. They're complaint investigations, they're licensure inspections. The agency can do all of them at once if it wants, or it can go out multiple times. So to distinguish between them in an actual opinion might cause a lot of problems that might not be anticipated. So I would caution this court to be careful about choosing a word if you were going to hold that. And I don't know what the best word would be to use. There's so many scenarios. And in addition, we also go out and look at things for the federal government during these surveys sometimes too for Medicaid clients. So, I mean, there's a lot of things that the agency can do at once. And that's why, there might be gaps in these surveys, right? Because we have to go do a lot of things for a lot of different facilities and a lot of different facility types. It's very hard to get there every 30 days.
All right, thank you, Council.
The agency rests on its brief. Thank you.
Mr. Terrell,
Okay.
whenever you're ready.
Okay, thank you. Yeah, so just want to follow up. 408 is the prevailing statute. 408 823.2 talks about how for ACA it prevails over everything, including this rule. There's nothing in 408 that gives such language as this rule that it should be a deficiency-free survey. Subparagraph 7A just talks about doing a survey. And the case that I cited, Beverly, in my reply brief, talks about substantial compliance. That's what's needed during these surveys, not perfection. And as far as exam versus a survey, I think those are different. I think exam is Judge Calderon is sort of what they were talking about in the Krakow case. You take an exam, that's pretty defined, and a survey that keeps going on and on, that's a different animal. I know I'm past my time, but I did want to comment on the burden of proof, but if I run out of time, can I just say one thing about the burden of proof?
Yes, sir. One thing.
Thank you. The cases that ACA cites are either initial licenses or deals with a foster care license. The MH case is a foster care license. That's not what we have here. We have a renewal license. And this court's decision in Coke says that the denial of a renewal license is a penal action. Under 120.571J, that means a higher burden of proof. The Haynes case, also a decision by this court, said that a foster care license is different than a professional license by
Mr. Terrell.
statute. Sorry?
And I believe that was in your brief as well, so we
Yes,
appreciate
thank you.
that.
Okay, I'll rest on my brief.
Okay.
I'll rest. Thank you for your time.
Thank you.
Thank
We
you.
appreciate your arguments today, and we will be adjourned.